my friends are simps.
There's been a lot of talk about copyright and fair use recently on here after a couple of parody videos were taken down in response to claims that apparently originated from, or at least were purportedly acting on behalf of teenage engineering. Now, in a lot of the discussions, I've noticed that there are some fundamental common misunderstandings about how copyright and fair use actually operate. This is understandable given the complexities involved, but it seemed worth at this point me breaking cover to give something of an overview to help people understand what the situation actually is and is not tied, to any one particular scenario. You might be wondering what qualifies this scruffy Scottish reprobate to speak with any authority on this nuanced topic, and that would be fair enough. However, believe it or not though, I am actually a lawyer, and this happens to be one of my specific areas of expertise. This isn't something I talk too much about on here, but it seemed worth me speaking up about. Before we dive in, I do need to make a couple of caveats and declarations. First of all, none of this should ever be treated as legal advice. Secondly, this video is only really intended to provide an overview of some of the most salient points about copyright and fair use on YouTube specifically. As you might appreciate, this is a topic which has got many additional layers of complexity and consideration, including the existence of YouTube's unique content ID system, but it's not going to be possible to cover all of that in any kind of detail. So if you're sitting watching this and going, but you haven't covered this point, then be aware that there is probably a good reason for that and some kind of rational thinking behind why not. With that said, naturally, I welcome you pointing out the deficiencies below because that helps feed the algorithm nicely, so go ahead. If you do find yourself wanting a more detailed dive into all of this, you can check out my journal article from 2019, which was published in the European Intellectual Property Review and is much more technical. It's a thrilling read, so you can find that in the link somewhere, probably below. The first thing you understand is that YouTube and other similar platforms are governed by something known as the Digital Millennium Copyright Act, or more commonly, the DMCA. This is a bit of American legislation that was originally enacted in 1998 and I think came into force in the year 2000, if I'm remembering correctly, partly to provide a clear mechanism by which rights holders could have allegedly infringing material swiftly removed from online service providers without having to go to court, while simultaneously also shielding those same service providers from any liability for the infringing actions of their users. And this is known as safe harbor. In other words, if somebody uploads one of my incredible electronic songs to YouTube without my permission, I can simply send what's known as a takedown notice to the platform and have that removed within a few days, as opposed to having to go through this lengthy and expensive course of legal action. So long as YouTube complies with the requirements of the law, I can't then, generally speaking anyway, sue YouTube for allowing that to happen. I mean, I could try, but I would almost certainly lose. The DMCA outlines a number of requirements for a takedown notice to be valid, including the provision of contact details, the signature of a person, and a number of other legal statements. The specifics of these aren't all that important for the purposes of this video, but you can find them on YouTube's support documentation if you're interested, and I'll also link that below. What is important is understanding that YouTube's copyright enforcement mechanism is built around the requirements of the DMCA. So in other words, it isn't something that they have just completely made up themselves. With this said, you don't actually need to make use of YouTube's dedicated takedown notice forms and tools in order to submit a copyright claim. In order to enjoy the protections afforded by the DMCA, every service provider is obliged to register what is called a designated agent that can receive takedown notices. If you go to dmca.copyright.gov, you can search for the contact details of every designated agent there is, including YouTube. Doing this means that you can completely bypass all of YouTube's forms and specific requirements that are outside what the law specifically requires, and email your takedown notice directly. You could also technically fax or post these as well if you are fucking mental. The problem of sending things indirectly, of course, is that you have to make sure that you craft the takedown notice carefully so that all of the various requirements of the law are included. Otherwise, your notice will be treated as incomplete or invalid and rejected. It is worth noting at this point that whilst there are many companies and firms out there that advertise what they describe as DMCA takedown services, you definitely do not need to hire a lawyer to write or send those takedown notices. They all have the same weight or legal effect, whether they're composed by you, me, or even Lionel Hutz himself, as long as they include the requirements laid out in the statute. As you're probably aware, YouTube operates a strike system. Each time your account is subject to a formally valid copyright takedown demand, you receive a single strike. If you accrue 3 strikes within 90 days, your entire channel is completely suspended, which can obviously be quite a big deal, especially if people are relying on that income. This 3 strikes and you're out system is a direct consequence of one of the DMCA's core requirements. Specifically, that service providers have to implement what's called a repeat infringer policy to make sure that people can't just continue to upload allegedly infringing material on an indefinite basis. Implementing and applying this policy in a consistent and objective way is really important, because courts have in the past held that where that hasn't happened, then there is no effective policy. Therefore, the platform can't enjoy the safe harbor protection. Interestingly enough, the law doesn't actually specify what such a policy should look like outside of the caveats that I've just given you. And so every platform has their own particular implementation. Why does it tend to be 3 strikes? Well, probably because Americans like baseball. And no, I'm not joking. This is almost certainly where that originated from. And it's often something that I find quite interesting, that culture has impacted law in this strangely arbitrary manner. But that's a by the by. Strikes on YouTube expire after 90 days, so long as you don't receive another strike within that period of time. However, you can also have a strike removed by submitting what is known as a counter notice. This is effectively a formal response to a copyright takedown notice, in which you have to make various assertions about the material being removed inappropriately, and also provide contact details. Upon receipt of a valid counter notice, YouTube forwards, or should forward anyway, all of this onto the original complainant for their consideration. If they then don't respond within 10 to 14 days to provide evidence that they will be initiating legal action against you, then access to the material should be restored and the strike removed. Before submitting a counter notice, you need to be very confident that you have the right to use the material in question, or that the original notice was invalid in some way. However, it is worth noting that complainants can take legal action against you for copyright infringement at any point, whether or not the video has been removed, or even in many cases, whether or not they have sent a takedown notice in the first place. This is kind of separate from that litigation. In practice, this is incredibly rare because taking somebody to court is very time-consuming and expensive. The priority for most complainants is just to have the material taken off the internet as fast as possible, and that is what the DMCA was designed to facilitate. This now brings us on to what's probably the most commonly misunderstood and also the most complicated portion of this whole topic: fair use. Fair use is a US legal doctrine which allows for the limited use of copyrighted material without permission in certain circumstances, including commentary or criticism, news reporting, teaching, scholarship, and research. There are similar protections in other jurisdictions, including fair dealing in the UK, but for our purposes, these are not relevant for reasons that I will come on to explain in a wee bit. Fair use has been described as the safety valve of copyright law, acting as a kind of counterbalance against the significant rights of exclusivity that rights holders enjoy. And this is often taken for granted, but it is essential to ensuring freedom of expression online. Fair use is what allows Google to use thumbnails in search engine results, preserves the ability for people to quote passages, for example, from books and journal articles or newspapers, and is also what enables people to make all of those god-awful reaction videos that clutter up your dashboard. Whilst this is an incredibly important portion of copyright law, there isn't a definitive list of uses or circumstances that are considered fair. Each instance has to be evaluated on a case-by-case basis and is assessed using what's known as the 4-factor test. By their nature, ultimate determinations on fair use can only be made by a court. However, that doesn't mean that the decisions are, or should be anyway, completely arbitrary, or that we can't predict what an outcome is likely to be. So on that basis, each situation, as I mentioned, is analysed with the use of a 4-factor test. And this includes considering 1, the purpose and character of the use, 2, the nature of the work used, the amount and substantiality of the use, and 4, the effect of the use upon the potential market for or value of the copyrighted work. So in other words, what are you doing with the material? How much of it are you using? And is that necessary for the purpose involved? These 4 factors have quite a lot in them that you can look at and analyse in various ways, but that kind of sums up the most salient parts. One of the most complicated aspects of fair use is the question of whether or not the use of material is transformative. So in other words, has the material been imbued with new expression, meaning or message? This transformation can come about from actively altering the original material to a significant enough degree, but even exact copies of work can be transformative if it has a different purpose from the original. Generally speaking, the more transformative the use, the more likely it is to be fair, and the less important the other factors become. However, use of material does not need to be transformative in order to be considered fair. And so you can see how this begins to get quite, complicated. A common misconception is that any kinds of edit or modification to an original work will result in transformative fair use, but that is very much definitely not the case. Acceptable levels of modification vary. It can either be extensive modification to the point that the original is almost unrecognizable, but in theory, they could also be very slight. The critical component here is that there has to be a fundamental shift in the nature of the expression itself. So in other words, or for example, I guess, if an advert is designed to market a particular product and somebody takes portions of that advert to mock the company, the use of that material would be for an entirely different purpose than the original. For this reason, not all reaction videos will automatically be considered to be fair use. I've seen plenty of examples where people literally just play entire episodes of a TV show and make some shocked faces in the corner. And from my perspective, that would not be transformative, uses a much larger portion of the original work than is necessary, and has often been used to generate views and ad income, so a commercial purpose which effectively impacts or replicates that of the original. Parodies are generally considered to be highly transformative, as their purpose is to criticize or mock the original or the company, I guess, involved in some way. And this is clearly different from the intentions of the original rights holder. With that said though, not all parodies will automatically constitute fair use, as each of the 4 factors still needs to be considered. So if there's a strong commercial element in the parody, that would count against the calculation of fair use, but wouldn't render it completely invalid. Now this is all quite dense, I think, so what's important to know here is that if you're going to reuse material without permission as part of your videos, you need to make sure that you're only using the portion necessary to make your point, and are accompanying it with sufficient commentary, criticism, or transformative purpose to ensure a really strong, clear, fair use argument. So this is all well and good, right? But I live in Scotland. If a cheeky German YouTuber decided to use clips of my video and I objected, what has American law got to do with any of this? Surely the laws of Scotland or Germany would apply. And kind of, but not really. If I decided to sue this plucky German scamp directly in court, then US law wouldn't actually be engaged at all, and we would instead enter into a specific legal framework to determine the most appropriate forum and jurisdiction that would apply. However, the important distinction here, for our purposes, is that the matter at issue is the ongoing publication of the material online. In other words, the takedown notice is aimed at YouTube as the host, rather than whoever the uploader is. And remember that the goal here is to have access to the material disabled as quickly as possible. So for all of those reasons, US law does apply. Now things can get much more complicated than this, especially if a platform has got a subsidiary in a region with a substantially different copyright enforcement mechanism and the complainant really wanted to be a pain in the arse. However, those tend to be exceptional circumstances, and we don't really need to worry about them for the general operation of the notice and takedown process. The important thing to know is that the individual copyright laws of the countries of the parties involved, platform aside, generally have little to no impact on the operation of the notice and takedown system on YouTube or on the assessment of fair use. So we're looking at US law for that. Now, the DMCA is notoriously flawed and abuse of the system is rife. This is something that I have written and talked about and campaigned on for a long, long time. The nature of the process means that it is entirely possible and actually quite common for folks to submit bogus takedown notices for content that they don't hold the rights to. And complainants consistently weaponize copyright in order to have critical speech taken down, completely, ignoring any fair use implications, even though they're meant to take these into consideration after the dancing baby case, which happened to be on YouTube. But anyway, I'm getting distracted here. Unfortunately, whilst there are some built-in penalties for this behaviour under Section 512F of the DMCA, they are largely considered to be completely ineffective and toothless. As a result, the main thing that creators can do to protect themselves from erroneous strikes is ensure, as I said, they have a really strong fair use argument and that they make use of the counter notice process where appropriate to contest unjust takedown demands. Now, I understand that this can be quite an intimidating thing to do, especially because you have to provide your contact details, etc. So the alternative is to share your story with the world via another video. People generally don't tend to look favourably upon attempts by companies to silence people in this way, and the Streisand effect can mean that very quickly those criticisms become amplified tenfold, with multiple videos popping up to cover the same topic, as we've seen kind of like this one, I guess. So to sum up, YouTube's copyright system is based on the statutory provisions of the DMCA. Fair use is more complicated than many people make it out to be, but you can also make educated determinations on what would be considered fair. And irrespective of what the law might say, companies that use copyright to get critical content taken off the internet are arguably acting in bad faith, or at the very least severely misguided. Hopefully this has provided some clarity on these points, given some perspective perhaps that you might otherwise not have had on the various conflicts that unfold on a regular basis on here, and helped you assess the circumstances in a more informed manner. With all of that out of the way, I'm now going to return to my usual programming where I don't talk about legal stuff. So if this has all been helpful in any way, you can find my link to Patreon down below, where I share all of my music, sample packs, blah de blah, and I really appreciate the support. Alternatively though, just leaving a comment below to, say this was worth watching through 20 odd minutes of, it also makes a big difference. So thanks in advance, and goodbye for now. Bye.